Good morning, everyone, and thank you so much for joining us today. My name is Merle Massey. I'm the coordinator for undergraduate research initiatives here at the University of Saskatchewan. And today we are recording another session for our SURE Student Undergraduate Research Experience Summer 2022 modules. And with us today, we have John Mapletop, who is a tech transfer manager with Research Excellence and Innovation. And John will tell you a little bit more about that, but I just wanted to say sort of a larger thank you to REI for the number of entrepreneurship modules that they have brought into the SURE program for students. I've had a lot of emails from students to say thank you for these particular sessions. So if you're interested in entrepreneurship, go check out, there's a whole section in our SURE YouTube page all around entrepreneurship, and it pulls a lot of these modules. But with that, I'm going to pass it straight over to John Mapletop, who's going to talk to us about intellectual property. Thanks so much, John.
Thank you, Merle, and thanks to the SURE program for having us today, and indeed for all the sessions that we're in, because we think it's a fantastic opportunity to participate in this program and communicate some of the things that we do with the rest of the folks on campus, in particular our students. So as Merle indicated, we're going to talk about intellectual property today, and some of the things we feel that are important to know, particularly in a university setting. So before I go into our overview here, I think my goal today, it wouldn't be to turn everyone into an expert in 1 hour, but maybe to just introduce some concepts to begin laying a foundation for those that start working regularly in this area in the coming months and years. When you see some of these concepts again, you might say, okay, I do remember a little bit about that. I've got a little bit of a foundation. I can do some Googling. I can recall some of the things we talked about. So I think that's the goal for today. So here's some of the things we're going to talk about. We're going to talk about what intellectual property is. We're going to go over several types of intellectual property, but of those types, we're going to focus a lot on patents, which of course cover inventions. We'll talk about in quite a bit of detail why patents are an important type of intellectual property at universities. Patents, of course, cover inventions for a period of 20 years. We'll talk about inventorship on patents, what makes someone an inventor. We'll go through a typical protection pathway for patents. We'll talk about assignment of ownership of patents. We'll also talk about the invention reporting process at this university, and it's quite similar to other universities. Finally, we'll talk about inventions becoming known publicly. That's known as public disclosure of inventions. And the last topic we'll cover today is licensing, which is the way that patents and other IP are transacted between organizations or individuals, the type of contract that is drawn up between those entities. And then hopefully we'll have some time for questions, comments, and feedback at the end. So just a bit of a disclaimer, IP laws do vary a little bit from country to country. A lot of countries around the world have come together and tried to harmonize their laws. So a lot of things are getting more the same and quite similar, but there are small differences. And really all I want to say here is that we're talking about things at a very high level today. And if you work in this area for any significant period of time, you probably will encounter some situations that don't quite fit with what we talk about today. So take everything with a little bit of a grain of salt in case some things don't exactly fit with the way we describe them here. Okay, so first of all, what is intellectual property? Basically, it's creations of the mind for which the law of whatever country you're in or want to work in grants you some sort of limited monopoly. So it's a legal property. So just like a house you might buy, you have certain rights to that. One of them for intellectual property is you have the ability to stop others from using or practicing that intellectual property. These rights are transferable. So again, just like a house, you can buy, sell, exchange these rights. But one interesting thing about intellectual property is the rights are usually limited in some way. And so, for example, we're going to talk about how a patent is a monopoly you get over an invention that the government gives to you, but it's limited. It only lasts for 20 years. Here's the types of IP we're going to talk about today. we're actually going to skip over patents. We're going to talk about patents for most of the presentation. So for now, we're going to skip over it and come back to patents. But before we do that, we're going to touch very briefly on copyrights, which cover creative works, as well as trademarks, which cover the names, signs, designs, and expressions that are associated with a business or product or service. We'll touch on trade secrets, which covers secret information. And then finally, we'll touch very briefly on the protection of plant varieties. So first of all, copyright. Copyright covers original creative works, but they must be fixed in a tangible form. So they can't just be ideas bouncing around your head. You have to kind of put the pen to paper, so to speak. So it could cover writing, stories, books, movies, dance choreography, songs and albums, as well as paintings, drawings, photos, and even software code. So the software itself, what the software does is not protected by copyright, but the written out software code itself is covered by copyright. One of the interesting things about copyright is it's granted automatically upon creation, even if the work is incomplete. So this means that as soon as you sit down and start writing your story, as soon as you start putting pen to paper or typing out your work, you have a copyright to that. So you have that copyright. Now, if you want to advertise to others that you are claiming your copyright, you can use the copyright symbol. That's the C with the circle around it here. And then you put that followed by the year the work was created and the author's name. So if I was writing my book on the first page, I could put copyright 2022 John Mapletoft. Again, remember that you automatically get your copyright without any action, but of course you can advertise that. You can even take a further step in registering it with a government office. Like in Canada, we have the Canadian Intellectual Property Office, CIPO or CIPO, and registering it basically provides evidence of creation. So the reason that could be important is, say I come up with this fantastic idea. I'm going to write this series of books on a bunch of wizards that go to school and have adventures with their friends and so forth. And I claim my copyright. I advertise to others on the first page that I'm claiming my copyright. I register it with CIPO, with the government IP office here in Canada in 2022. And 5 years from now, someone claims, oh, you stole my stories. And then I say, wait a minute, I registered it back in 2022. Here's my evidence of the date I created this work. So that's the value there. That's optional, but that's something you can do to kind of increase your level of protection on your copyrighted work. Now, copyright is theoretically limited. It lasts for a period of time after the creator's death. I believe that period of time is something like 50 to 70 years after the creator's death. However, in practice, it's seeming like recent materials really don't have any sort of expiry on the copyright. If you go back to works created before the early 20th century, those are all in the public domain. Anyone can take and reproduce a lot of the early Sherlock Holmes novels, for example, the ones that were created before copyright laws such as these came into effect. But really, I and a lot of other people, we refer to these as the Walt Disney rules, because Walt Disney died in about 1966 or so. And every time the copyrights on a lot of the Walt Disney's original works start to look like they're going to expire, the Walt Disney Company, along with a lot of other companies that have a vested interest in this, a lot of media companies, they get together and lobby governments to get the copyright extended. And they've done that several times successfully. And I fully expect that they're going to continue to do this. So even though copyright is theoretically limited in time length, in practice, it seems like it's continually getting extended and likely will continue to do so. Now, trademarks, on the other hand, they cover names, signs, designs, and expressions associated with businesses that identify products and services. In many countries, rights are established simply through use. So again, I start my business, I call it John's Biz, and so long as no one else is operating under that name, particularly in my region or in the type of business I'm running, I can potentially have a trademark on that without any further action. And if I want to advertise to others that I'm claiming my trademark, I can do so by using the trademark symbol, which is the superscript TM. Now, just like copyright, you can take an additional step. You don't have to take the step, but you can take an additional step and register your trademark with a government IP office. And if you do so, you can then use the registered trademark symbol, which is this R with a circle around it. It's a use it or lose it system. And what that means is that so long as you're continually using that name, sign, or design with your product or service or the name of your business, you can potentially have the protection on that in perpetuity. However, if you stop selling that product or service, if your business goes under, or you start marketing your business, or stop being active with your business for any period of time, you theoretically could lose that trademark. It could go back in the public domain and someone else might be able to pick it up. Now, as we discussed, trade secrets covers secret information such as formulae, practices, processes, designs, patterns, methods, or compilations. And there's a couple key things here. One is that it has to offer some sort of benefit to the holder of the information. So some sort of secret information that gives you a competitive edge or helps you do something. The other thing is you have to be able to demonstrate that you are attempting to keep it secret. So if you have hard copies, you're keeping them under lock and key, you're password protecting computer files. One of the biggest things that companies do with trade secrets is they maybe make it so that no one person has access to all the information. I believe this is the case with both the Coca-Cola formula as well as the 11 herbs and spices for Kentucky Fried Chicken. They have them broken down into sub-recipes. So you might have parts A, B, and C, and one person gets to see part A, another person gets to see part B, and the third person gets to see part C, but no one gets to see all parts A, B, and C together. And protection around trade secrets is more related to the legal threat for inappropriate use. So if someone stole the secrets, they moved to another company and shared the secrets without permission, if they violated a confidentiality agreement, that sort of thing. One of the interesting things about trade secrets is there's no term on protection so long as it's kept secret. So again, we come back to our couple examples there, the Coca-Cola formula and the 11 herbs and spices for Kentucky Fried Chicken. They've been kept secret for literally, I believe, more than 100 years now. So just a note on trademarks and trade secrets. And again, we hinted at this with the Coca-Cola and Kentucky Fried Chicken examples. This is sometimes a better strategy than patenting, particularly in food products, nutrition, consumer products, supplements, energy bars. And my favorite example, because it came from a university, is Gatorade, which was developed at the University of Florida College of Medicine in the 1960s for their football team. And that's how they came up with the name. They're aiding their Gators on the football field. And they could have patented this formula, but instead they trademarked the name and they kept the exact formula secret. Now, of course, with foods, you have to publish the ingredient list, but you don't have to publish the exact amounts or the processes you're using to manufacture them. We'll just very quickly touch on protection of plant varieties. I have to admit that I don't do a ton of this, but on campus, our crop development center does do a lot of this. So I expect that they would be quite knowledgeable about this topic. It does give the breeder of the new variety exclusive rights over the growing and harvested materials from the new plant variety. There's four criteria that have to be met to protect a new variety. It has to be new, and they define new as that it hasn't been on for sale on the market for a period of more than 1 year. It has to be distinct in that the new variety has one or more important differences that distinguish it from known varieties, in particular the varieties that it's been derived from. It has to be uniform in that all the plants of the variety exhibit these traits. And it also has to be stable. And what they mean by that is generation by generation, when you propagate the plant, you don't lose these traits. The breeder names the new variety. And something interesting to note, and again, we're going to start talking about patents here in a minute or two, is that you could have variety rights and patents on the same plant. And the reason that that might be important, an important distinction, is because there are some IP protection exemptions when you're talking about plant varieties. One of the biggest one is saved seed. This allows farmers, if they purchase a protected variety, they can save the seed from that and replant it the next year. However, if there also happens to be a patent on that same plant, they may not be able to do that without the permission of the patent holder. There's also compulsory licenses that can be brought into play for plant varieties. And a compulsory license just means that the government says, hey, we're forcing you to license this plant variety to other people. So you imagine something like maybe there's a food security crisis or something like that, and the government looks at the plant varieties that have been developed in Canada and says, okay, we think some of these varieties could be important for helping with this food security issue. We're going to force the people that own the intellectual property on those plant varieties to issue compulsory licenses to anyone that wants to grow it. And that as part of that compulsory license, the government might say, okay, we're going to set the terms of the license. This is how much you're going to get paid each time someone uses the plant variety you own, but you can't say no to this deal. You have to give these licenses to anyone that can grow it. So that's something that it's probably not commonly done, but that exists with plant varieties, and that may not exist again if there's also happens to be a patent on that plant. Before we talk about patents, I like to just to kind of recap the different types of IP we've talk about the Coke bottle, because it actually features a number of the types of IP we just talked about. So again, we're gonna talk about what patents are, but patents cover inventions. They cover things that do something. So you have to imagine that back when bottle caps were brand new and nobody had ever seen them before, there could have been a patent on the function of the bottle cap. Indeed, Coke does have trademarks on the name, the logo, but also even the shape and look of the bottle. They have a trademark on that, and others are not able to copy the shape and look of that bottle. And then finally, as we discussed, they have a trade secret on the cola formulation. And then kind of a little bonus question for a bit of discussion here, and we already hinted at this. For a formula, are you better off going with a patent or trade secret, and why? And kind of as we hinted at, there can be some major advantages to going with a trade secret if you are indeed able to keep that secret. And the main one is there's no term on protection. As we're going to talk about with patents in just a moment, part of the deal with a patent is you have to tell the world exactly how your invention works. That's to foster innovation. That's why the patenting system came about. Whereas with trade secrets, you don't have to tell anyone. In fact, you have to do the opposite. You have to keep it secret. But the benefit of the terms of the trade secret is, whereas a patent expires in 20 years, the trade secret you can keep essentially forever. And so you can imagine 100 years ago with things like Coca-Cola and Kentucky Fried Chicken, if they'd patented their formulas, they would have had their 20 years protection. But after that, they would have been up for grabs by anyone that wanted to use them. On the other hand, they kept their formulas secret, and still to this day, nobody knows exactly how they make those products, and presumably 100 years from now, they will still be secret. Okay, as we discussed, patents cover inventions. So these are compositions, methods, devices, or processes. They're basically things that have a function, things that do something. And again, it's a 20-year legal monopoly. But the key here is this is in exchange for putting all the details of the invention in the patent. So the idea that was that, and the governments came up with this, I don't know, it was about 150, 200 years ago, is people were keeping all their innovative inventions and processes secret, and nobody was sharing anything. And the government said, geez, we could really help foster further innovation if we give people a monopoly over their inventions in exchange for publicly disclosing them. And the way this will work is it'll be a limited time. They'll get to have exclusive rights over their invention. And then after the 20 years, anybody can use it. Now, a tricky concept here, something that's totally counterintuitive, is what a patent is it's the right to stop others from using or practicing the invention, okay? It's the right to stop others from using the invention. It's not actually a right to practice your own invention. So that seems very strange at first, but I'll give you a made-up example to kind of illustrate this. So let's imagine we go back a couple hundred years ago when they first started the patent system, and we imagine that before that, nobody had ever invented a chair before, okay? And before that, everyone had to either stand or lay down, and there was nothing in between. And someone comes along, I've got this wonderful new invention. It's a three-legged chair. No longer do you have to stand up for your meeting, stand up while you're working. You can sit down while you're visiting, while you're reading. This is fantastic. It's a wonderful invention. He goes down, he gets a patent on it, and he sells millions of them, and everything's great. There's only one problem with this three-legged chair is it can be a little bit of a safety concern, because if you lean too far one way or the other, you can actually flip over your three-legged chair. So someone else comes along, they say, okay, I see a great way to improve this three-legged chair. This is a great product, but I can make it even better. I can add a fourth leg to this chair, and it's even better than the three-legged chair. It's much safer. It rarely flips over. I'm going to go down and indeed get a patent on that. And you can definitely get a patent on improvements to someone else's invention, but there's only one problem. If you look at three-legged chairs and four-legged chairs, what do they both have in common? Well, they both have at least three legs. So if I have the patent on the four-legged chair, I actually can't practice my patent without violating the three-legged chair patent. So again, this is a bit of a weird situation, and you might actually think that this could prevent innovation and prevent the development of new products and technologies, but it turns out it's actually the opposite. And I'll kind of hopefully help illustrate this. So if I'm the three-legged chair guy, I've got the patent, I see this four-legged chair patent come out, and I say, geez Louise, what am I going to do here? Well, actually, one of the best things I can do is offer to partner with the four-legged chair patent person. And we can work together and extend the legal monopoly on a new product. They can't practice their patent without me, and I want access to their patent to have an improved product or service. And indeed, that happens all the time with patents. A lot of patents are incremental improvements on older things, and the old folks and the new people, they partner quite often. So it actually does lead to a lot of innovation. And we see that quite a bit at universities as well, because universities are often working on improvements to existing things. So just a quick note on inventions versus discovery. Inventions, as we talked about, are patentable, whereas discoveries are not. Discoveries are simply new knowledge, whereas inventions are basically the application of the new knowledge. The invention has to do something. It has to have a function. It can't just be knowledge sitting there. So for example, if you were to figure out the cause of a disease, that would simply be a discovery. Whereas if you come up with a new molecule that disrupts or prevents a disease, that could be an invention. Again, it has to do something. So there's 4 criteria to make something patentable so that you have a chance of getting the patent. It has to be new, and that means no knowledge of the invention exists in the public domain. So that means nobody else has come up with this idea or talked about. But something probably even more important at universities, that you yourself haven't previously publicly disclosed the invention. So again, at universities, we tend to be about sharing information and fostering new knowledge. So we want to be very careful if we're going to patent things. We're not saying never share the information. We're just saying investigate the patenting process first, get your patent application in, and then share the information publicly. So again, that's the thing we have to be careful about most at universities, is the sharing of information on the invention before we've actually looked at the patenting process. The second criteria is it has to be useful. At universities, that tends not to be a problem, because all of the things we tend to look at and do research on at universities, it tends to be to solve problems that exist in society. So if you come up with a solution to those problems, that's inherently useful. Now, the next criterion here is a bit strange, a bit abstract. Inventions have to be non-obvious to those skilled in the art. And what that means is you have an expert in the area that the invention exists in. They wouldn't simply look at that and say, well, yeah, that's the obvious way to solve that problem. So that means you have to often exhibit a little bit of synergy. It can't just be a situation where you slap a couple things together and you get 1 + 1 = 2. It's more a situation where you add 2 things together and you get 1 + 1 = 10, or something surprising about the result, such that an expert in that area wouldn't necessarily expect that that's how it would work. And finally, you have to show that your invention works. We call this reducing it to practice. having a working prototype, or having data that show the invention works. Next, let's talk about inventorship. This is actually defined by law. We can't just say, hey, we're going to take all our friends and put them on the patent. People have to either contribute to the original idea, design of the invention, or in the solving of key problems in getting it to work. So just because you work on something, just because you work very hard on it, doesn't make you an inventor, particularly if you're just following instructions or doing basic calculations. Just because you put the team together, or you're the boss, or you paid for the work, does not make you an inventor. And in particular at universities, a lot of the time we're publishing on the same thing that we're inventing. And just because you're an author on the paper doesn't make you an inventor. Academic authorship is decided basically by people on the project, whereas again, inventorship is defined by law. And someone must come up with the idea or get it to work. That's how you become an inventor. And then a final note here is inventorship is not the same as ownership. Recall that intellectual property can be transacted, bought, sold, just like a piece of regular property, just like a house. However, an inventor will always remain an inventor on that patent. So again, that patent could be bought or sold, ownership could change, but the inventor list will always remain the same. Okay, so why do we patent things? And I think one of the things maybe we all think about when we hear the word patent is we think dollar signs. And indeed, in university-owned inventions here at U of S, inventors receive 50% of the net revenue realized from their inventions. And then inventors out in society, we often think about them coming up with brilliant inventions and making money off them. So again, that is an incentive to drive innovation, and some inventors do get wealthy off their patents. But there's also another reason to consider patenting, even if your interests are completely benevolent, and you might think that the best way to help society is just to give your invention away for free. A patent could still actually be important for getting your invention out in the world and helping people. And the reason for that is very few inventions, particularly inventions at universities, are ready to go to market, ready for people in society to use them at the point where you filed a patent application. In fact, when you may have spent hundreds of thousands of dollars on the research to get the invention and get your patent application in, there could still be millions, tens of millions, maybe even hundreds of millions of dollars worth of work to go into that invention to get it to market. You have to think, again, the things coming out of universities, drugs, oiled field and mining inventions, improved technologies for agriculture. A lot of them have regulatory processes with government authorities you have to go through. You have manufacturing, you need to get your manufacturing consistent, make sure your product works unit after unit after unit. You need to ship it around the world. You have to have a distribution network. And then you need sales and marketing folks to actually get the product into the hands of the people that can use it. And so generally speaking, unless you have very wealthy relatives or are independently wealthy yourself, you are going to need to partner with others to get your invention to market. You're going to have to potentially partner with investors, partner with big companies that have done this before, that have those networks, that have that manufacturing, that have the experience with the regulatory authorities. And really, in order to entice these partners to participate, that's what your patent does for you. It allows you to say, hey, you can enjoy an economic reward, you can get some economic benefit because of the monopoly we have on this patent if you invest your resources in the development of this and help us get it to market. So again, even if you want to give your thing away for free, a patent could be important to actually getting it to the people that need it. Okay, next we'll go over the typical patent protection pathway that we use here at U of S. A lot of universities use this, and indeed, this is a pretty good protection pathway for really anyone, but it is maybe a bit unique in that it defers a lot of as much cost as possible, keeps the cost relatively low, especially for the early years of the patent application. And we'll talk about why that's important in a few minutes. So the first step, and these underlying terms, we're going to come back and talk about them, is to report the invention to the university and assign ownership to the university. And once we start talking about an invention and completing the invention reporting process, that can take a few months. And at this point, zero money has been spent on the patent application itself. The university will then take a couple months to figure out if the invention is patentable and if we can identify a market for it, and then work with the patent agent to draft the patent application. At that point, we then move to file what we call a United States Provisional Patent Application. This is a placeholder application issued by the United States Patent and Trademark Office. The reason we go there first is this placeholder application is honored around the world. So this initial application lasts for about a year, and we try to synchronize it with the first public disclosure of the invention. So we'll talk more about public disclosure in a few minutes, but of course, remember that something has to be new. It can't be publicly disclosed before you file the invention. But on the other hand, as soon as you file your patent, you're starting the clock ticking on that 20-year patent life. So you want to be able to delay filing it as much as possible in most cases and wait until right before you know that invention is going to be publicly disclosed. This initial application costs around $10,000 with paying for the patent agent's time and effort on it. At the end of that year, we often convert it to something called a Patent Cooperation Treaty or PCT application. This costs around another $10,000, and this one lasts for another year and a half. So we've got about 2.5 years of early patent protection for about $20,000, which the university will pay for university-owned inventions. And after that, we have to nationalize. And this is where it gets pretty expensive, because all around the world, they honor these initial 2 applications. But at the end of that 2.5 years, you now have to go into each and every country and territory in which you want protection. And this gets very expensive. You're talking tens of thousands of dollars per country. So you can imagine if you're looking for a fairly broad protection around the world, you're getting very easily into the hundreds of thousands, if not $1 million or more to do this. So again, this isn't the only path, but it's kind of optimal in terms of maximizing protection and minimizing or deferring costs. And the university would pay for this $20,000, and that would give us 2.5 years. And what do we do in those 2.5 years? We basically try to find a partner. Recall that we're going to need help to get these inventions to the people that use them. And part of that, again, is finding that partner and finding a partner that's willing and able to pay those patent costs in the territories that they deem important for the advancement of that technology. And unfortunately, if we're not able to find a partner by the time that PCT expires, we will often either allow the protection to expire and no longer have a patent on that, or we might in some cases keep it alive in just a couple countries, maybe like US and Canada, for example, because that is cheap enough to do that we could do that here at the university. So here's what that looks like graphically over here on the left-hand side. Ideally, several months before we expect the invention to be publicly disclosed, I've just put 6 months here on the left-hand side. We start working on the invention report with the inventors. Again, no money's been spent on the patent at that point. Around 3 months before we expect the invention to be publicly disclosed, that's when we maybe finalize that invention report. Our office goes to work on it. We determine that it's patentable. We determine that we can identify a market for it. We file at time point 0 here. We file that US provisional patent application for about $10,000 that the university pays for. And we try to time that for just immediately before the invention becomes public. That buys us a year of time. 12 months later, we file that PCT application. That's another $100,000, another $10,000 that the university pays for. And again, the whole idea here is in this year and a half, we find that industrial partner before the nationalization costs go into the hundreds of thousands of dollars. Okay, so we hinted that we would talk about assignment of ownership of inventions to the university. So what does this mean? It literally means you're giving ownership of the invention. And in this case, we're going to talk about is giving this to the university. So why would you do this? One of the reasons you might do this is because you have to. If we look historically at the university here, undergraduate students do not have to give their inventions to the university, but graduate students, postdoc, staff, and faculty used to have to give their inventions to the university, and that's as per the collective bargaining agreements that they belong to. And the rule of thumb that I use to kind of remember who had to give their inventions to the university, if you are paying to be at the university, you own your own inventions, whereas if you're getting paid to be at the university owns your inventions. And this is inventions relating to your work at the university. Now we've launched a new inventions management approach this year. And this approach is simply that in order to attempt to foster development of more companies and get more inventions moving towards market and helping people, we've decided that even if the university would own an invention, we're going to offer it back to the inventors to see if they want to take it on, if they feel that they have the means to do so. And again, it depends on what your goals are in your career and in life. If you have a wealthy aunt or uncle, if you have your own company already set up, if you have investors, this is going to be a more attractive option to you to own your own patents. On the other hand, if you're focused more on your career, your academic career, that's your day-to-day, that's where you want to focus your time and effort, and you don't have the money sitting around to pay for patents, you might say, no, I'm very happy to work with the university and use the university to pay for those early IP protection, marketing, and transaction services. And even if you do that, there still is an economic upside if you assign ownership of your invention to the university. And that is at U of S, inventors get 50% of any net revenue realized from that invention. So if you assign ownership to the university partners up with someone to commercialize that invention, any money comes back, we make any money off that invention, the inventors will get 50% of that, and they don't have to put any of their own money into that. Okay, we hinted at reporting of inventions. This is the formal process of communicating to the university that you have an invention. So this applies, I'll talk about this, but it applies mostly to people that formerly had to assign their ownership to the university. And this is important even if you want to own your own invention, because the university needs to know what you own. If you're claiming you own your invention, it helps if you can articulate, here's the piece of paper that says from the university that I own it. So in some ways it's never too early, but again, I've put the number here 6 months before you expect the invention to go public, and we'll talk about what that means in a moment. That gives us 3 months to kind of finalize the invention report, and another few months for us to evaluate it, figure out if it's patentable, figure out if we can have a market for it, work with the patent agent to prepare the patent application and get it ready to file. And this uses an official report, invention report form template that you can find on our website. And honestly, the easiest way to do that, if you wanted to take a look at this form, is just to Google USask invention report. And that is the easiest way to find it on our website. Okay, we hinted at public disclosure. What is this? Essentially, this is when the invention becomes public. At universities, this is often by the publication of a paper or other written material. This includes online publication. If something appears on a website, it's considered published. That includes Twitter, Facebook, things like that. It also includes early publication ahead of conferences. So if you submit abstracts, things of that nature. It includes verbal disclosure, PowerPoint presentations, seminars, conferences, even casual conversations. If you go down to your local pub or restaurant and you start blurting out details about your invention in public, that invention is now publicly disclosed and can't be patented. Something important to note here is even local events. You think about things like student seminars, student poster days here on campus, even those constitute public disclosure, unless the door is locked and it's a by invitation meeting only and nobody else is allowed to be there and people are checking to make sure that only the invited people are there. It is considered a public event. Okay, so we filed for a patent. Now what do we do? Again, we're usually trying to find that industrial partner before the PCT expires. And what do we want to do? And that's when we start to talk about licensing. So a license is basically the contract or agreement that's used to transfer rights from one entity or individual to another. So again, here we're trying to license the patent to an existing company, or in some cases, even to a startup company. So what is a license? Again, it's how these patents are transacted, and it's a license essentially is an agreement granting permission. So you think about a driver's license, what is that? That is the government granting you permission to operate a motor vehicle. So in this case, we're granting somebody else the right to use our intellectual property. And we usually want something back in exchange for that. And typically what we do is we ask for royalty payments, a percentage royalty payment made on the dollar sales of that invention once it makes it to market. So we're going to very quickly go through some of the things we discuss in a typical license negotiation. I would not expect anyone to memorize all of this. Again, we're just trying to introduce the concepts. And so I think if you encounter these later in life, months from now, years from now, you might say, okay, I remember a little bit about that. This is starting to make sense. I've got some context here. And I know at least enough to Google some of these things and figure out their meaning again. So these are the different license agreement terms we'll discuss very briefly. We're going to look at them from three perspectives. We're going to look at a typical university license agreement, and then we have two licensing programs here at U of S. One is called our FAST license. The idea there is we've kind of pre-set out a bunch of what we hope are very industry-friendly terms, very friendly terms that the company would look at and say, these terms actually sound really great. And if the company is willing to accept all those terms on the spot, we don't have to go through a negotiation. They can just have a license to the technology they're interested on the spot. We also have something similar, but a little bit of difference, requires a little bit more negotiation. It's if we're licensing to a startup. Again, startups won't have the deep pockets and resources that a larger company does. So we sometimes change just a few of those terms to kind of help those startup companies out. Just a note on terminology, I'm actually going to try to avoid this terminology, but you might see this out in the real world. The licensor is the party granting the license, the party giving permission, whereas the licensee is the party receiving permission. So I get these mixed up all the time. If you ever encounter these terms and you can't remember which is which, the easiest thing to do is just Google what is the difference between a licensor and licensee. Okay, so first of all, field of use. That's the areas the company is allowed to use the patent in. So this could be unlimited or restricted. So for example, we could say, we're only granting you the rights to use this for the treatment and prevention of human disease X, or for oil field applications, or for veterinary and animal health use, but not for human use, something like that. That being said, in our quest to kind of be more friendly to industry and foster more easy innovation, we tend to make our field of use and our licenses unlimited. And the reason for that is technology development is very difficult. Sometimes circumstances change. Sometimes companies have to pivot. So we don't want to limit them too much in how they're approaching it. Again, it's very unlikely that someone that's interested in developing a drug for disease is going to all of a sudden want to develop that drug for oil field or mining. That doesn't really make sense. But maybe they originally thought that they were going to develop it for one disease condition, and it actually turns out it's better for a different disease condition. So the easiest thing we found is just not to worry about limiting that. The grant is actually what kind of permission is being given by the university. So this could be an exclusive license or a non-exclusive license. If it's a non-exclusive license, that means we can license it to other companies as well. And again, you remember, what is a patent? It's kind of a monopoly on things. So a patent is most valuable when you're not giving it away to everybody, when you're only giving it to one company that gets the monopoly on that technology. So that's where the license is most valuable, if it's an exclusive license. So indeed, most of the time we do grant exclusive licenses. But the one thing I will say is we usually retain non-commercial rights to continue doing research on and teaching about the invention. So that's something we ask for, and typically companies don't have a problem with that because they're interested in the commercial rights. Sub-license rights. This is the company allowed to grant further licenses of the technology? We call those sub-licenses. In a typical university license, you might have no sub-license rights, or you can sub-license, but you need the university's permission to do that, or you can sub-license, but here's the list of conditions. Here's the list of things you have to put in your sub-license agreements in order to do this. We grant companies full sub-license rights, but we don't force them to get our permission for them to do sub-licenses. We just ask for them to notify us when they do sub-licenses so that we know what's going on. Again, we're trying to make this very friendly and easy for the companies to advance the technologies. We don't want to put a lot of limits on them. Territory is which countries the license, the permission is being given in. Could be worldwide or could be restricted to specific countries. Again, making it industry friendly, we tend to do worldwide licenses. Duration, how long does the agreement last? Typically for the patent life, and the reason for that is after the patent expires, you no longer have a legal monopoly on that technology, so you can't bind anyone to any terms around your patent, and that includes the company you're doing the agreement with. So that company could continue to sell the product after the patents expire, but they won't owe you any royalties or anything like that afterwards. Patent costs. Who pays for patent costs? Again, as we move forward, remember that we were quite concerned about the potentially expensive patent costs that could occur if you want to patent all over the world. And so basically the deal is we say to the company, okay, we're giving you a license to this. Well, we'll let you decide where you file patents in all over the world, but you're going to pay for that. And for established companies, we say you're going to pay for all the patent costs. That includes the patent costs that the university may have already spent to get the patent started. And this is one place that our startup or smaller company license starts to diverge from the license we grant to more established companies. And we might make a bit of a deal with the company here. One typical thing we'll do is we may not ask them to pay the back patent costs, the patent costs that the university has already incurred, and we might make a bit of a deal on the forward patent costs as well. We still generally think it's important for them to pay forward patent costs, particularly if they are the ones deciding where to patent, because of course we can't have someone else making the decision, oh, we want to patent in every country around the world, but we're not willing to pay for it. Royalty on sales. This is the money that the university gets back if the product is successful and makes it back to market. In a typical situation, it's usually a low single-digit percentage of the dollars being sold for those products or services. We found in our negotiations, these negotiations would take weeks to months. We'd always start at 5% and we'd go back and forth, and we'd always get whittled down to 1 or 2%. So we just said, well, again, we're trying to be really friendly to industry here. We're trying to get these negotiations concluded quickly. Why don't we just start at 1%? We can just do the deal at 1%. We would sooner have a smaller slice of more pies, a smaller slice of bigger pies of products that actually make it to market, or make it to market more quickly than a bigger slice of a pie that never makes it to market, or that we slow down and takes more time to get there. On one hand, you might think, well, the university came up with these inventions, the inventors came up with these inventions, why do they get such a small percentage? Again, recall that in a typical research program, you might have spent hundreds of thousands of dollars on the research coming up with this invention. But for most inventions, there's still a long way to go. It takes millions, tens of millions, even hundreds of millions of dollars to do the field testing, to work with the regulatory bodies, to manufacture millions of units, to distribute them around the world, to pay your marketing and sales forces. So companies and other partners really are doing the vast majority of the lifting in getting these products to market. Again, recall, we can give companies the right to sub-license in these agreements, and the sub-license compensation is merely the percentage of that revenue that goes back to the university. Change of control percentage. This is the percentage of the acquisition price that goes back to the university if the company is sold. This again is a spot where our startup license diverges from the others. And if you think about it, say we're licensing one new technology to a big, well-established company like IBM that already has thousands, if not tens of thousands of technologies and patents in their company. And if we're adding one more to that giant pile, we're not really moving the needle much on value of that company. So IBM would say it's absolutely ridiculous that you would expect us to give you part of our multi-billion-dollar, possibly trillion-dollar acquisition price if our company was sold. Now, a small company, on the other hand, a startup company that might only have one or two technologies in the company, in that case, that one technology is adding substantial value to that company potentially. So, and we're also doing some favors, some other deals, helping them out with costs, the patent costs, for example. So it seems much more fair in that circumstance to say, hey, if your company is bought by a larger company, that we want to share a little bit in the proceeds if that company is sold. Milestones, these are goals that must be achieved by the company to keep the license. So these can be things like, we're going to reach this stage of clinical trials by next year, and the next stage by the year after that. We're going to be manufacturing at this scale by this year, or have the product on the market within 5 years. And the idea here is that if they don't meet that goal, you can yank the license back from them. Now, what we found in practice is that even if a company didn't meet its milestones, we were very rarely actually yanking the license back. In most cases, even if a company doesn't meet its milestone, it's still, the technology has a better chance of success staying with that company than yanking it back and starting from scratch with another company. So basically, we were just continually negotiating these milestones. And that's not that surprising, because development of new technologies is unpredictable. It is difficult. So it's maybe not surprising that milestone dates were always changing. But we thought to ourselves, okay, we're trying to be industry friendly. We're trying to speed things up, not slow them down. If we're always renegotiating the milestones anyway, why don't we just get rid of them? We'll just say, so long as you continue working on the technology, so long as you're attempting to progress it, we're not going to yank the license back. And indeed, that's what we've put into our agreements. And then finally, I believe this is the last one, talking about upfront payments. This can be anything from thousands to tens of thousands of dollars. In rare cases, could be hundreds of thousands. And this is something, oh, we feel our technology is so valuable. As soon as you sign that agreement, you're going to start paying us. However, we've concluded in our dealings with companies that we don't want $1,000 up front. We want thousands of dollars, hundreds of thousands of dollars a year once that product makes it to market. We want to help you do that. We want you to invest your money in development of the product, not just paying us off. So our philosophy is basically, excuse me, that you, other than patent costs, you shouldn't have to pay us any money until our invention starts making you money. Okay, so those are the basic terms of a license, and indeed our FAST license. We post our FAST license online. Again, you can go to the website, or the easiest thing to do is just to Google USask FAST license. At that website, we have on the right here, we have our simple one-page term summary sheet you can look at. Something else we have also have on that website is the Full-Bodied Agreement. It's about a 20-page document written in legalese by lawyers. It is not very stimulating reading, but one could just look at it to get an idea of what the actual agreement looks like. And if you are having trouble sleeping at night, something that you could do is pull it out and start trying to read it page by page. And I expect that by the third page, you will probably put yourself to sleep. But that being said, the full agreement is there on our website for everyone to look at. And it could, again, I don't necessarily recommend you try to read the whole thing. You could just look at it, look at the headings to kind of see what a license agreement looks like if you're interested. So with that, we're just starting to wrap up here. I think some of the important things to remember is this pathway where you start talking about the invention, doing the invention report several months before you expect the invention to go public. You the university files that US provisional application for $10,000. A year later, we convert it to the PCT application. We're spending about $20,000 over that first year and a half and trying to find that partner for the company to both advance the technology to market and pay for those expensive patent costs. Again, just recall that we're talking about things today in a very general sense. The laws do vary from country to country, and certainly if you work for long enough in this field, you will find some situations that don't precisely fit with what we've talked about. So finally, just some do's and don'ts. I think commercialization opportunities, even if you are focused on your academic work, can be an exciting diversion, an exciting side story to your work, an opportunity to have fun doing something a little bit different from the standard research and academic work. And indeed, commercialization can even be used to leverage research opportunities, different types of applied grants, partnerships, sponsored research from companies, things like that. On the other hand, there's some don'ts. It's probably generally not worth fighting over or burning bridges over early intellectual property, and also potentially not worth quitting your day job unless you really want to do your own startup company, and that would be a whole separate presentation to talk about that. And the reason for that is 95% of inventions never make it to market and never earn a dime. And you might say, geez, John, that's a real downer way to end this presentation. And on one hand, you're right. But I'd like to remind everyone that like all the great things we have in the modern world, whether it's new medicines that have been developed over the past few hundred years, transportation, telecommunications, smartphones, even things like televisions, the internet, video games, all these great, wonderful things we have in society. These are on the back of intellectual properties that were developed and had the odds against them, and yet people still found a way to succeed. And so that few percent that do succeed are absolutely transformative in society and change people's lives around the world, and also often make a few people rich in the meantime. So we think this adventure is one that's absolutely worth embarking on if you have the will or the means, and we're here to help people get started on that path. So with that, I'll close up now and see if we have a couple minutes for some questions and comments. Here's my contact information. I'm generally not too difficult to reach. You can Google my name and USask if you're trying to find me. My colleagues as well are very excellent to speak to on these matters. And we're happy to talk about general questions about how things work, as well as if you have a specific case, you're thinking about inventing something, you think you may have invented something, we're very happy to discuss that. So with that, I'll maybe shut up for a little bit here and see if there's any questions or discussion.
Thank you so much, John. I learned so much. It's interesting as an author myself to remember that, you know, when I sit down to write something at home, not so much my work stuff, of course, that's university, but you know, any of the books that I've published or whatever, I don't think it's really hit home to me that, you know, the minute I put, you know, a paragraph to the page, that's my copyright. I've created something that didn't exist before. I hadn't really thought my way through that, but certainly that was really quite fascinating. John, I've got a question, and you might or might not have the answer to this, but in a typical year, how busy is your office? How many patents, how many licenses, what's coming through REI's office in a typical year?
Yeah, so one of the metrics we look at is kind of the new invention disclosures. And I want to say it's usually around 30 or so.
Oh, wow.
You know, give or take, so maybe 20 to 40, like in a very busy year, we might be the high 30s and we're often in the 20s for new inventions disclosed. We also often have a lot of conversations where not necessarily an invention report is filed, or they're like, I've got to go back to the drawing board and do more work. I might file something next year maybe. And so in addition to those 20 or 30 or more that we receive, There might be, another dozen or 2 dozen more where we have initial conversations and they don't quite get to the point of disclosing the invention. So I'd say that is probably the metric we would talk about about the kind of input of innovations into our office each year.
I think that that's really fascinating, and it lets you know the sort of the robust and vivacity that's going on across the university. I think that's great. If any of you have questions for John or for there's a few other members of REI who are here as well, you can either put them in the chat or feel free to unmute yourself and ask them. And I'm going to keep the recording going for this time because I know that sometimes the questions that come in elicit an answer that everyone would like to know. Of all the things that you've worked with, because you've been here at the university for a while, John, what was the most interesting patent or invention that you've had the fun to work on?
Yeah, I mean, there are quite a few different things. One of the most interesting, just by virtue of the sheer economic activity it generated, was a pig vaccine invented by researchers at the Western College of Veterinary Medicine. And it has literally had a multi-billion-dollar effect on the porcine industry around the world. The product has literally sold, I don't know what it is, something like $10 billion. That's probably the product that has impacted industry the most. Something else, to give a different example, talking about a different type of intellectual property, because again, we've focused a lot on patents today. We have a group in our College of Pharmacy and Nutrition called USask, and they've developed a set of prescribing guidelines. As you may be aware, pharmacists are allowed to prescribe for a very limited few number of things and conditions, as opposed to having to go to the doctor to get this. And they've developed kind of an algorithm and laid out kind of the answers to what pharmacists are allowed to prescribe for, and here's the ranges of things, and here's what you can prescribe for them. And this has turned out to be quite a valuable resource that in the past couple of years, we've started licensing this resource, and we've protected it as a copyright material, and we've licensed it out to all sorts of different companies and organizations, including other universities, pharmacy professional associations in different provinces, pharmacy companies themselves. So the pharmacy that you actually go to get your prescription, we've licensed to those companies, as well as other companies that offer products and services to those pharmacies, software as a service companies that want to incorporate those MedSask prescribing guidelines into their software that they offer for sale to the pharmacy. So I think those are probably a couple interesting examples that show kind of some of the diversity in things that have come across my desk.
That's really, really fun. What an interesting office you get to work in. I didn't notice anything come in on the chat. Flag me if I've missed anything. But John, thank you so much for presenting for us today and giving us such an excellent overview of yes, we do research, but there's things that we can do with that research and to take it and to share it further with the world, but to protect it and do it well and do it successfully. There's lots of clapping going on, so thanks very much for being with us today and sharing your wisdom and all your knowledge.
Not a problem, and definitely happy to continue the conversation if anyone would like to reach out to me.
That sounds fantastic. Thank you so much, John. Take care now.
Bye-bye.